Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where are we coming from? Well, this is beautiful Central Washington, right here near Blewett Pass, outside of Cle Elum, Washington. Listen, we spent a lot of time talking about forced reset triggers, wide open triggers, all the letters that the ATF started sending out, the nasty little grams that they were sending everyone. I got a chance to talk to a whole bunch of you around the country. I ended up helping you with that headache that was the ATF. And then along came all the lawsuits, and really, much like everything else that the ATF had done, it kind of, got choked out because, candidly, as we know, it wasn't so much what they were doing, but how they were doing it. Along came the case of Cargill v. Garland, the bump stock case. And while many of us thought that this might be a very advantageous ruling for us, much like Rahimi, there turns out to be a bunch of problematic language in there, and that has got the ATF all excited about their determination on forced reset triggers and wide open triggers once again. So today, let's geek out on some supplemental authorities that they filed, and let's talk about, did ATF's trigger rule just get new life? Okay, so the case that we're talking about today, America, is National Association for Gun Rights against Garland. It is one of several challenges to ATF's sudden and rapid determination that forced reset triggers, wide open triggers, standing on their own, actually constituted unlawful machine guns. Now, as we know, many of you had problems. Some of you cut those triggers up. Some of you had me talk to the ATF on your behalf, but eventually the lawsuits dropped, and eventually NAGR, through some very, very good lawyering, was able to obtain injunctive relief while this case is pending arguments on the merits. However, along comes Cargill, and sometimes courts will ask for additional authority. Sometimes they'll still be like, hey, this case just came down. How does that change the complexion of this case here? And then sometimes the parties will just say, hey, you really need to check this out. I'm not sure what spurred this, but what really does happen is we got ourselves a supplemental memorandum of authorities by the United States Department of Justice here in support of their rule for forced reset triggers and wide open triggers. And what are they saying? They're saying, well, if you take a look at Cargill, it says so. Now, I'm going to link up the memorandum down below because it gets into a very, very long technical explanation about how machine guns function and how FRTs and wide open triggers function. But essentially, what the United States government is arguing here is that the FRT is the same as an autosear, which you would find in an automatic weapon. I'm going to give you kind of a brief description of what the United States Department of Justice is claiming here. By contrast, with a machine gun, a shooter can fire multiple times or even continuously by engaging the trigger only once. A machine gun firing automatically does not use a disconnector, instead using an autosear. The autosear catches the hammer as it swings backwards, but will release the hammer again once a new cartridge is loaded if the trigger is being held back. Functionally, the autosear briefly retains the hammer between shots to allow the weapon to safely reload, and then is automatically tripped by the bolt carrier of the weapon to fire the next shot. But here's what the Department of Justice says. The FRT and wide open trigger likewise eliminate the need for the shooter to release and re-engage the trigger between shots, instead allowing a shooter to engage the trigger once to fire repeatedly. These devices have no disconnector to interrupt the firing cycle. They instead achieve continuous fire through the locking bar, which serves as the same purpose as an autosear. The locking bar momentarily delays release of the hammer until the weapon is safely reloaded and ready to fire again, and the locking bar is automatically tripped by the bolt carrier to enable another shot. Okay, so do you get what they're saying? They're saying, listen, the disconnector and the autosear is essentially the same component, and therefore the FRT standing alone, or the WOT standing alone, constitutes an unlawful machine gun. DOJ also claims the chief difference between the locking bar and an autosear is that while an autosear retains the hammer directly, the locking bar does so indirectly by briefly restraining the movement of the trigger. In a firearm with an FRT or WOT, the trigger thus moves as part of the automatic mechanical process of retaining and releasing the hammer. But those separate movements of the trigger are part and parcel of the device's automatic operation and do not constitute separate and distinct functions of the trigger. Now, in typical fashion, the Department of Justice starts splitting hairs and getting rather disingenuous or rather expansive in how they want to interpret some of the language within Cargill. But much like Rahimi, if we don't use extremely concise language, what we see is we see these quotes pop up over and over again. Take, for example, what's happening here in this case. Cargill underscores the correctness of ATF's longstanding treatment of devices like the ones at issue here as machine guns. As the court explained, the dispositive consideration is how many shots discharge when the shooter engages the trigger. This understanding and the court's explication of the terms trigger and function mirrors the long-standing view of this court and others that a trigger fundamentally serves to initiate the firing sequence of a weapon. So if you really take a 35,000-foot view of what the Department of Justice is claiming here, is they're saying, hey, listen, it's kind of close enough. And since it's kind of close enough, well, then the holdings of Cargill should apply. Now, if you really want to concisely understand whether or not this is an effective argument, consider this point right here. Unlike non-mechanical bump stocks, these devices entirely replace a firearm's trigger assembly. Most significantly, these devices lack a disconnector, the component of a standard semi-automatic rifle trigger that holds the hammer and prevents the firing of further shots until the shooter takes pressure off the trigger and allows it to move forward. As a result, these devices do not require the shooter to release and re-engage the trigger or take pressure off the trigger for each shot. And then, of course, they know this because the ATF did some very thorough testing on these triggers. Yes, in fact, they did do some very interesting testing because you gotta have to pay attention to the details. I want you to understand how the ATF has made this determination because really, even if everything that they were saying here, take it for the truth, make it an arguendo here, right? What you're also going to see is how they tested it. Well, it doesn't quite mimic real life application because the Memorandum of Authority specifically states, instead, as plaintiff's experts explained, the weapon will continue to fire even if the shooter does not lessen his rearward pressure on the trigger. ATF testing confirmed the same by applying a metal cable tie to the trigger to apply continuous pressure and observing that the weapon fired repeatedly. That's right. ATF's testing did not involve a human being, but rather a cable tie. Now, I know what many of you are saying is no, listen, even with the FRT and the wide open trigger, the trigger has to function each and every time. And that is true, actually. It does have to function each and every time. So we know how bogus this argument is. But I need you to understand where the Department of Justice is coming from because you know there's going to be some courts that are going to totally buy off on this argument because this is how they take apart the more common sense argument. Plaintiffs have contended that these devices are not machine guns because each movement of the trigger constitutes a separate function, arguing that the trigger must separately function to release the hammer by moving far enough to the rear in order to fire the next round. But Cargill did not embrace that rule. The court instead repeatedly emphasized that with a semi-automatic weapon, a shooter must release and re-engage the trigger to fire another shot, while with a machine gun, a shooter can fire multiple times or even continuously by engaging the trigger only once. And I will say that the one thing that is unique about these components, unlike bump stocks, okay, is that these do actually replace a critical component necessary to the operation of the firearm. And the Department of Justice hangs their hat on that big time. Plaintiffs may seek to rely on Cargill's language that on weapons with these standard trigger mechanisms, the phrase function of the trigger means the physical trigger movement required to shoot the firearm. That language concerns only standard trigger assemblies for semi-automatic weapons, not replacement trigger assemblies like the ones at issue here. And Cargill described that physical trigger movement as encompassing not only the initial engagement of the trigger, but also the subsequent disengagement of the trigger by taking pressure off the trigger, which was necessary to complete the process of a single function of the trigger. Okay, so what we can see the Department of Justice is doing here is two things. Number one, they're taking some pretty sloppy language that was placed in the Cargill opinion and using it to their advantage. And we're already beginning to see the Rahimi case be used in such a fashion as well. Secondly, what they're trying to do is they're also trying to make a very similar argument that, well, these are relevantly similar. And what I mean by that is well, it's kind of close enough. The disconnector is close enough to an auto sear, and since it's close enough, the holdings of Cargill tell us that our rule is correct. Whether or not this truly breathes life back into this suit, that remains to be seen. However, this is not the only suit which is challenging the legality and constitutionality of ATF's rulemaking as it related to these triggers. And therefore, in some other jurisdictions, I'm quite worried that this is going to breathe new life back into these arguments. The case, once again, is National Association for Gun Rights v. Garland. We'll link it up down below so you can geek out on it for yourself. We're also going to link up a link down there, so if you want to show some love to the National Association for Gun Rights, you may do so. Maybe you got questions about this or anything else related to what's left of our Second Amendment rights. If you guys do, you should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. Maybe you got an idea for a video we should be doing here. Hey, if you do, go ahead and click on that link right there. Candidly, most of the good ideas we came up with, we didn't really come up with at all. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From beautiful Central Washington, thanks for watching. Stay safe.